Lordship, और supplementary list serial number 40 Lordship, कल 40 जी Lordship, कल इसको मेंशन किए थे Lordship, आज के लिए लगा हुआ है। अपोजिट साइड के वकील साहब के घर में डेथ हो गया है, तो उन्होंने कहा कि इसको मंडे के लिए
अब छुट्टी के बाद ही
Lordship, कल इसका डेट कल फिक्स है एग्जीक्यूशन कोर्ट में फॉर द डिलीवरी ऑफ पोजीशन के लिए।
कैसे
इसमें लगा हुआ था Lordship,
डिलीवरी ऑफ पोजीशन इशू है
नहीं हुआ नहीं, कल डेट इसलिए फिक्स है।
स्टे ऑलरेडी था
जी स्टे था।
कहां है ऑलरेडी गई
ऑर्डर टू
ऑर्डर नहीं है आपके पास
है
इतना पुराना ऑर्डर
205
नहीं
सर
मंडे के लिए ना किया था Lordship, उनके घर में डेथ हो गया इसीलिए।
डेट हो गया तो मंडे को आ जाएंगे वो
मंडे को आ जाएंगे, उनसे बात हुई है।
ठीक है मंडे को अब वहाँ पे ये सर्टिफिकेट दीजिएगा कोर्ट ने मंडे के लिए फिक्स किया है यही कहानी है ना आप लोग का
नहीं
फिर क्या फिर बताइए इसके अलावा क्या करिएगा आप बोलिएगा कि मंडे के लिए फिक्स हो गया ऑटोमेटिक स्टे करिएगा हम लोग बहुत लंबा प्रैक्टिस किए हुए इसलिए हमको पता है आप क्या क्या कर सकते अब जितना चीज सोचते हैं ना उससे 10 गुना हम सोच के आपको बता सकते हैं आप क्या क्या कर सकते हैं कोई नहीं
From supplementary list of financial item 1, second appeal 85 or 1994.
Yesterday, we had already referred as to how and why substantial question number 1 was raised. Now only to refer the finding of the appellate court with
I am
respect.
still not able to figure out substantial question of law 1 का क्या relevance है आप हमको बताएंगे please you just explain it what is the impact of substantial question of law suppose the substantial question of law is answered in his favor what will be the consequence because substantial question of law में क्या मतलब है जिसका कोई bearing होना चाहिए ना केस में अगर मान लीजिए इनके फेवर में डिसाइड होता है तो इसका क्या बियरिंग या आपके फेवर में डिसाइड होता है तो इसका क्या बियरिंग क्या कोर्ट ने इस प्रिंसिपल को अप्लाई किया है टू डिसाइड द केस
Yes, sir. Therefore, I was referring.
और अगर मान लीजिए इनके फेवर में या इनके अगेंस्ट में डिसाइड होता है इसका क्या कॉन्सिक्वेंस है और किस प्रॉपर्टी पर इसका कॉन्सिक्वेंस है
Yeah, that is to be
That is to be ascertained. क्योंकि जो सेल्फ एक्वायर्ड प्रॉपर्टी है वो तो क्लियर कट फाइंडिंग है दैट इज सेल्फ एक्वायर्ड प्रॉपर्टी सारा का सारा प्रॉपर्टी 36 11 and 110 पर ही है
self acquired property है he was weaver.
हां वो तो क्लियर है उसमें तो कोई स्कोप ही नहीं है
But this question has been duly answered by the appellate in subsequent paragraph 17 and onward.
yes let us have a look at the question once again
Yes.
कल का एक जजमेंट आप लिख लीजिए फर्स्ट अपील मेरा फर्स्ट अपील का आपको भेज दूंगा
Order dated 16/8/1995.
और वो 93 वाला चाहिए ऑर्डर डेटेड
16/8/1995.
प्लीज एंड
Whether the inference drawn by the learned appellate court regarding partition of the property between the plaintiffs and the defendants on the oral and documentary evidence regarding separate measures and cultivation between the co-sharers legal and such inference is available under Hindu law can also be made available to
इज लीगल है ये जो हैंडराइटिंग में करेक्शन है ना वो काट के नीचे इज दे सकते हैं इज लीगल एंड सच इंफरेंस ये क्या पता सिग्नेचर
such inference is available under Hindu law can also be made available under Mohammedan law. My submission is that concept of Mohammedan law is different than Hindu law.
That's right.
There is no law with respect to Mohammedan unity of title and possession.
यूनिटी ऑफ टाइटल तो नहीं है, यूनिटी ऑफ पोजीशन तो है.
Possession हो सकता है,
हाँ.
but unity of title is essential
It is
ingredient.
alien. It's completely alien.
It
to Mohammedan law.
is essential ingredient for a partition of the property. Therefore,
Let's be clear on this. Unity of title is not available for Mohammedan. Unity of possession is it?
both are to be proved by plaintiff with respect to the property in between plaintiff and defendants.
You see, the previous finding in connection with this plot number, khata number 36, 11 and 110 is that there was previous partition on the ground that they were separate in mess and cultivation completely. And one judgment has been relied on 1998.
Yes.
What's the name of the party?
Got 93.
93.
But that is referred in the appellate court.
Yes, that is referred in the appellate.
Both have been referred here, and there is one judgment of Hindu law, that is 1984 PLR 603, 1993 Volume 1 PLR page 172, and the third one was 1936 Patna page 68.
So we are concerned with three judgments.
Yes.
One is
93 Volume 1 PLR
Volume 1 PLDR
page 172.
172.
पेज
पार्टी का नाम बताइए सर.
पार्टी का नाम है देखो
जियारत हुसैन.
Yes.
That's it. This I have.
I passed on block.
ये मिला.
हाँ.
ये
Same.
सुप्रीम कोर्ट वाला है.
पटना
नहीं बस सुप्रीम कोर्ट.
हाँ. Okay. This is one. The second one is
second one is 1984 PLR
1984 PLDR
603 इसके पार्टी का नाम
60
वीर चंद्र राव
हाँ लोट हम पास
Vijan Rao.
कर.
Yes. और इसके अलावा
third one is AIR 1936 Patna page 68
पटना पेज नंबर 68.
बुकराम राय.
सबसे पहले पुराना वाला जजमेंट देखते हैं. इन तीनों जजमेंट को प्लेस तो करना होगा.
Blood by trade is also referring one judgment. It is correction AIR 1971 Patna page 215.
1971 पटना 215.
215.
Guys,
कॉपी है.
तो हम लोग जो सीक्वेंस से पढ़ेंगे 36 पटना पहले. प्लीज करिए. हाँ पढ़ी प्लेस करिए सर जज
ये थर्टी
Student 36 Patna, page
Yes.
number 2, second paragraph.
Yes, I'm reading.
Both the courts below have held that the parties separated in status many years before the suit, and the lower appellate court also disbelieved the defense case that there was partition about 90 years ago. The decision of first court is that the defendants have succeeded in proving that the plaintiff had been separate from them in family status, in ownership of property, and in possession, except in respect of the lands admitted in the written statement to be held by both parties in common tenancy. The learned district judge affirms these findings, but as he has also definitely found that there was no formal partition between the parties, the decree passed by him will assert on the ground that even co-sharers, though separate in status, may claim partition of the family properties which have not been partitioned by mates and laws. The fact of present case, however, seems to be somewhat similar to the facts of the case of 53 Bombay 213, which was decided by Privy Council. In the present case, the parties have been in possession of and have been exercising right of ownership over separate blocks of land for a long time, and in such manner that a court might well presume that these lands have already been divided, and the right of parties defined in regard to them in such manner as to preclude their being repartitioned. But in any event, the finding of learned district judge that the defendants have acquired titles also more than 12 years seems to be sufficient to dispose of the appeal.
So what do you want to say from this? What do you want to say from this judgment?
since the parties are living separately since long, dealing with their property since long, Exhibit D and D1.
Since when are they dealing with separate?
1940, more than 1940, Sheikh Baga के मरने के बाद से partition हो गया था. Now the only thing I would like to refer, that is the recital of the sale deeds, Exhibit D and D1, in which it is clearly held that अपने हिस्से का
ये तो फाइंडिंग में अपने हिस्से का बेचे
अपने हिस्से का बेचे हैं. हिस्सा कब होगा? जब पार्टीशन नहीं हुआ तो 1/3 बेचे, रेस्ट नहीं बेचे. एक ही 2 प्लॉट का 1/3 बेचे, रेस्ट नहीं बेचे. Therefore, blood referring activity and D1 will clearly say that there was partition, and it has been taken note by the appellate court.
ओन शेयर का बेचने से कैसे प्रिजम्पशन हो जाएगा कि पार्टीशन?
ये कहीं लिखे अपना हिस्सा, यही हम रेफर करना चाह रहे हैं. अपना हिस्सा बोल के नहीं लिखे.
फिर क्या लिखे?
स्पेसिफिक बाउंड्री उसमें दिया हुआ है. प्लॉट नंबर 1667, रकबा 46 डिसमिल, जमा रकबा 51, मध्य अपना हिस्सा 16 डिसमिल जमीन जिसका चौहद्दी उत्तर दोन क्या है बुद्धूराव, दक्षिण दोन पुल महतो वगैरह हकियत रहती अंदर कलाकारी डिस्ट्रिक्ट कलेक्ट्री और डिस्ट्रिक्ट रजिस्ट्रार सच एंड सच. और नीचे में 4 लाइन के बाद है उसके हिस्से पर आता है. वो दखलकार हैं मुतजकिर वाला जमीन एक उनके हिस्से पर आता है. पेज 2 के रेसाइटल में स्पष्ट लिखा हुआ है दोनों डीड में.
ये प्लेंटिफ का डीड है.
एक डिपेंडेंट का डीड है, एक्सिक्यूटेड बाय Sheikh Bigar
हाँ
in favor of Sheikh Rahim.
इसको इसको एग्जीक्यूट किसने किया? प्लेंटिफ है।
Plaintiff है.
Okay. So you want to say that since long they have been dealing with their property separately, and therefore this principle, if a person deals with the property since long, whether it's Hindu law or it's Mohammedan law,
Mohammedan.
this principle would apply.
Apply.
Although there is difference between Hindu law and Mohammedan law. In Mohammedan law, there is no unity of title, but there is unity of possession in law.
Possession. Even unity of possession, it cannot present a claim partition on the basis of only possession. Because unity of title is different thing, unity of possession is different thing. And it has been thoroughly dealt with by the appellate court. Now
This is
let
one. The next judgment.
PNGR, page 603. Let para 7. Para 7. This is to two of very material.
Para 7 mention. Two of the very material documents which were referred to by the trial court and the trial court, though considered these two documents along with others, took a view against the defendant appellants, have not been considered, much less referred to by the lower appellate court. These documents are Exhibit A series. Exhibit A sale deed dated so and so executed by so and so in favor of one so account. By this deed, 10 doors of land, plot so and so was transferred. Exhibit A by 2 is another registered deed and it discloses that Ramata plaintiff had sold 2 kattas of plot so and so to Gandhar Raj. These two documents executed by no else than the plaintiff to himself are very material for being considered as they speak of conduct of the parties as prevailing 12 to 14 years before the institution of suit. It is well settled that where the parties have been in possession of a land exercising right of ownership over separate blocks of land for a long time, the court might well presume that these lands have already been divided and the rights of the parties defined with regard to them in such manner as to preclude the being repartitioned. In view of such settled principle of law, the aforesaid two documents are so material as needed to be considered by the final court of trial.
And third one is 1993 Vol. 1 PNGR, page 172.
1993.
Where the relevant paragraphs are paragraph 40 and onward. Next.
Yes, Barapot.
In this convention, it may be mentioned that this aspect of the matter has been considered by full.
It is well settled, Mr. Shivora. Barapot.
In this case, it has also been held that there is no question of representation in Mountain law.
That's right. कहाँ से पढ़ रहे हैं?
ये para 40 से पढ़ रहा है.
Para 40 आपका मैच नहीं कर. It is well settled that the property
Yes.
can be transferred.
Yes.
यही. ये तो नॉन जॉइंटर पर है उसके
हाँ, non-jointer पर है.
पैरा 47 क्वेश्चन नंबर
47.
इट इज एडमिटेड पोजीशन
Yes. नहीं, कुछ गड़बड़ है.
क्वेश्चन नंबर बी देखिए जस्ट लुक एट क्वेश्चन नंबर बी
नंबरिंग
नंबरिंग अलग अलग रिपोर्ट का अलग अलग नंबरिंग
Question number B.
नेक्स्ट नेक्स्ट
Definitely, here the para partition begins with further this in this case.
सर को जरा दिखाएंगे यहाँ से
देखो मिला के
बट आई विल मार्क
the question B.
ये
Yes.
56 यहाँ पे
56. Yeah.
It is an admitted possession in
Question B is being answered.
हाँ yes
that unlike Hindu joint family, no presumption arises in respect of joint Mohammedan family that the same continue to be joint. Even in relation to a Hindu joint family, the presumption is stronger in cases of full brothers, and such presumption gets weaker and weaker by passage of time. Mr. So-and-so relying on or on the basis of section 110 of Indian Evidence Act contended that as possession follows title, the state of affairs as existing at the time of the entry in the survey settlement record of rights must be held to be continuing, and thus the onus to prove previous partition was upon defendants. The submission of Mr. So-and-so is only stated to be rejected. It is admitted by the plaintiffs that the parties are in separate possession of land. It is also admitted that even at the time of preparation of survey settlement record of rights, parties were found to be in separate possession of land. Thus, if provision of section 100 of Indian Evidence Act is made to apply, the same shall run counter to the contention of Mr. So-and-so. The plaintiff has filed suit for partition. One of the essential ingredients for grant of degree of partition is proof of unity of title and unity of possession. In the instant case, different parcels of land were recorded in the name of different persons. Admittedly, so far the suit land is concerned, the same was recorded in the name of Chonar and Dina having 2 shares and Madan and Jodi having 1 share. The lands appertaining to Khata 300, which was the subject matter of title suit 52 of 57, were recorded in the name of Chonar, Dina and Mabod, 2 sons of Guna having 3 shares, Jaga son of Jutan having 1 share, and Jodi son of Bihari having 1 share. The record of right is not a document of title. No materials have been placed on record to show as to how some of the sons of common ancestor, Guna Mia, acquired different sets of properties. In such situation, it has to be held that the properties appertaining to Khata 82, namely the suit land, as also the properties appertaining to Khata 320, which was the subject matter of title suit 52-57, did not form part of the joint family property. As has been conceded by Mr. So-and-so, under Mohammedan law, the doctrine of representation is unknown. All co-sharers have a definite share, and as noticed herein before, admittedly, so far as the suit lands are concerned, the parties have been in possession of different parcels thereof. It is admitted that the parties are in separate possession of the land in question. It is also admitted that even the rent is not being paid jointly in respect of the said land. It has further been admitted that by reason of several deeds of sale, namely sale deed dated so-and-so, different co-sharers have transferred specific lands and not their undivided share. It is also admitted that the daughter of plaintiff, Zulekha Khatun, had also purchased some lands from Inamuddin Mia. It is therefore evident that although no direct evidence of partition was available on record, the defendants have been able to bring on record several facts wherefrom an inference of partition can be drawn, which may be enumerated as under. The suit lands were not included in the earlier suit for partition, namely title suit 50 of
this feature is not applicable
not no. Despite the fact that the plaintiff in the plaint questioned the deeds of sale, namely Exhibit A series, PW 8 in his
this is sale deed this is applicable
admitted that all the sale deeds are genuine and the purchasers are in possession thereof. It is further admitted that the rent receipts are being granted in their names in respect
यहाँ
of
पे
the
rent
land.
receipt is
in joint. That is name of common ancestor.
common.
Common.
in respect of the land purchase and they are in exclusive possession thereof. The plaintiff in para 30 of his deposition has further admitted that the deed of sale executed in favor of Julekha is valid, although as noticed herein before, in the plaint he described the sale deed, the said deed of sale as false.
Let's pause here for a moment. Some of the factors which have been considered here, serial number 1 is not available. So far as second is concerned, that different specific shares has been sold, that is there. And the name of common ancestor, the rent is being paid in the name of common ancestor. This is also an agreement fact. Still it is being paid in the name of common ancestor.
DW1, who had been siding with the plaintiff, has also admitted that there had been partition and the parties are in possession of the lands according to the shares. PW5, Badri Prasad, in para 12 of his deposition, has also admitted separate cultivation. PW8, in para 19 of his deposition, admitted that transaction made by Kasmali. In para 26, he admitted the transfer in favor of Julekha despite statements made to the contrary in the claim. In para 28 of the deposition, he admitted that the heirs and representatives of the recorded tenants are in possession of the land in accordance to their respective shares. Apart from the above aforementioned deeds, the defendants have also brought on record various rent receipts, which are exhibit so and so, which also show that rent is being paid separately. DW1 has further stated that Rahmadul Ansari had also purchased the land in the Khata 82 from Ishaq Noor. He also stated that the plaintiffs have also purchased land of Khata 82. The said sale deed, as noticed herein, has been marked Exhibit 1. Coming to the oral evidence, PW4 Mohammad Amin appears to an incompetent witness inasmuch as he stated that he did not know anything about the suit lands, nor he could say as to in whose name the same have been recorded. PW5 Badri Prasad, as noticed here before, admitted that the plaintiffs and defendants are cultivating the suit land separately. PW8 Jairat Hussain also stated in chief that there had been no partition of the suit by means and bounds, but as noticed herein before, he made several admissions which have been recorded by the learned court below in para 27 of his judgment, which have also been noticed by me earlier. In this connection, it may be mentioned that the circus settlement operation took place in the year 1911-1912 in the district of Hazaribagh. According to the defendants, the parties partitioned the land by meet and bound within 3 to 4 years of final publication of report of right. It was therefore impossible for the defendant to prove partition by direct evidence. The plaintiffs could not prove the case of unity of title and unity of possession. On the other hand, with the cumulative effect of circumstances as mentioned herein before, namely separate residence, separate possession, separate payment of rent, separate transaction, and cultivation of lands separately for a long time by the same branch, may lead to an inference of previous partition. In Radhamoni Bhuya versus Divakar Bhuya, reported in AIR 91, Patna 95, this court observed that true, it is as suggested by Mr. So that there has been no direct evidence of partition, and the two defendants who examined themselves as DW3 and 4 could not have been the witness of actual partition. However, in the instant case, not only the parties are in separate possession for a long time, that is for a period of 70 years, but they are also in separate mess and having separate residence for more than 70 years. The trial court itself had come to a conclusion that there has been a partition of the properties inter se amongst the plaintiffs. It is now well settled that although there is a presumption of jointness in Hindu family, but that presumption is stronger when the parties are full brothers. But such presumption gets weaker and weaker as the time passes, and the parties in third or fourth generation are found to be in separate possession of land. From a perusal of the Khatiyan Exhibit C and C/1, it appears that no plot whatsoever has been shown to be joint. In that case, therefore, on the basis of said circumstances, it was held that there had been a previous partition of a joint Hindu family. In view of the presence of the same factors, inference of previous partition of a Muslim family can also be drawn.
Yesterday we
So
have
same principle can be drawn for principle for
Mohammedan law.
Mohammedan law also.
Yes.
That if they are shown separate for a long time and
Long
these factors are being satisfied,
Yes.
then there can be a situation of previous
Yes.
condition.
Now
One thing which arises that the rent has been paid, was being paid, but considering the question of law, the court has drawn an inference of previous partition based on the conduct of the parties, the evidences based on record, and also taking into consideration the sale deeds. It is not the only sale deed has been considered, that is not good. The court has considered every aspect of the matter. Even the court has also considered that a smaller portion has been allocated to the plaintiff, and there is a reason for that because that was a valuable property,
Yes.
more valuable property. That explanation is also there.
there.
That finding of fact is not in dispute. What is in dispute is whether the principles can be applied. By virtue of this judgment, principles can be applied.
Yes.
This is what you would like to say.
Yes.
At best.
Yes.
What all judgments are there? Other one is 91 Patna, 172.
That is the same principle.
In addition to those judgment, I have placed one judgment.
दो जजमेंट उन्होंने अभी और नहीं प्लेस किया है.
Arjun Mahto and
अर्जुन महतो ने प्लेस किया है.
Arjun Mahto and others versus Munda Mahtai. In this
Yeah.
judgment also the same principle.
बताइए कौन सा
In the
पैराग्राफ?
paragraph number 25, my lord. On the basis of certain sale deed inter-se transaction, it has been held that if the parties were dealing with separately with their lands of within their separate possession, it would be not inference.
बीच ऐसे नहीं लेक्चर वन देखिए बताइए.
Para 25.
पढ़ी.
Nitai Mahto PW4 has admitted in his evidence that he had sold some suit lands to Jabu Mahto, defendant number 5, and plaintiff number 5, and 6 had also sold some suit lands to Ramu Mahto, and he had witnessed the sale deed. In my opinion, the admission of Nitai Mahto, plaintiff number 1, which has been duly proved, can be used against him, and much weight in the circumstances of this case is to be given. There is no denial by the plaintiff of the facts admitted on the basis of sale deed. Exhibits Q and Q1. It can be safely said that the descendants of Ritu Mahto had partitioned the land of Maujadir side left behind by Ritu Mahto and exercised ownership over them. And subsequently included in paragraph number 34. But separation in food and residence for a long time among the brothers of Hindu family, independent transaction of property, separate possession, enjoyment of properties are by themselves not conclusive to prove the partition, but the cumulative effect of such acts may show that there had been partition between the brothers during their lifetime. In this connection, it is profitable to refer to the decision of the Privy Council in Gangabai versus Hemro Goda, Somaya Goda, AR 1930.
There is one more judgment, 1991, 93 Patna, 172. Why do you want to refer to this?
That is the same Lord Vivad said, that is the same judgment.
Same judgment.
Same.
Vehicles. ये 9 is Supreme Court. This one Supreme Court. Supreme Court judgment भी आपको सही करना है. मेरे पास कॉपी है पता नहीं. मालूम पात्रा. 2009 volume QSCC 562.
Oh, probably that was given yesterday on the ground of partial partition not permissible under Mountain law.
Do you want to argue this?
That has been dealt with certain properties which has been sought for.
partial partition का कोई issue नहीं है.
Issue नहीं
plea नहीं है.
नहीं है नहीं
तो फिर इसको छोड़ दे.
Absolutely.
क्योंकि फिर that will be going too far. आपको क्या हो गया? एक सेकंड मैडम, आप किस क्या कर रही हैं ये बताइए. आप she's an amite.
Yes.
Let me just hear her. Yesterday when I asked her in the second half, she said that I'm assisting the ambulance, and so you are not supposed to assist her. You have to only assist her. Yes, come here. Yes, madam, tell me.
हम लोग एडमिट दिख
हाँ, बिल्कुल.
As far as there are basically two substantial questions of law, and we are going to confine to the substantial question of law itself, which is one is whether the inference drawn by the learned first appellate court regarding partition of the properties between the plaintiffs and defendants on the basis of oral and documentary evidence relating to separate mess and cultivation is legal and permissible under Mohammed law also. And second is whether in spite of clear and categorical admissions by defendants number 1, 9, 10 and defendant number 1A to 1C in their written statements admitting that Khata number 36, 11 and 110 are joint family properties liable to partition, the suit of the plaintiffs could legally have been dismissed. These are the two questions. Coming to the formulation with the admitted facts of the matter is that there was
The facts we have already heard. We have read enough. What is the law?
the law is that
What is the fine distinction between Hindu law and Muslim law?
Lordship, in the Hindu law, Lordship, just reading. There is a concept of joint family in Hindu law which is absent in the Mohammedan law. In Mohammedan law, there is tenants in common, which is there. So the basic, so there is no presumption of partition or jointness in Mohammedan law. Upon death, property devolves immediately and definitely on heirs, and heirs hold as tenants in common, not as joint tenants. And there is no presumption of partition or jointness. Partition must be proved as a fact, and it cannot be inferred merely from separate living, separate cultivation, or separate enjoyment.
But when you say that it cannot be inferred, this is the first substantial. Whether in the circumstances can it be inferred that there was a divorce. With the passage of time, it may not be possible to actually prove the partition. Whether the circumstances, one of the circumstances that the plaintiff is dealing with the property, दोनों में specified boundary है, दोनों में specified boundary is dealing with the property, having specified boundary, and claims that it is his specified share. Then under such circumstances can we presume that there was a previous partition on the conduct of the plaintiff himself. So this is the. Is it necessary that there has to be a proper partition drawn and there has to be a document to that effect? Oral partition is permissible in Mohammedan law?
It should be recorded in the sense that there should be witnesses to it or something.
This is in connection with gift, etc., hiba, etc. But when it comes to partition, is it a requirement in law that there has to be some kind of documentation in connection with that? Or there can be oral partition?
They can do it.
What about the second substantial question of law?
Lordship, the second substantial question of law, there is clear admission in written statement, then from by decree number 1, 9, 10, 1A, 1C. So, section 15 of Evidence Act says that facts admitted need not be proved. So, it's an admitted fact that there was a jointness of the properties.
This is qua some of the defendants.
Yes.
Will this admission apply to other defendants?
No.
So, admission of one defendant cannot be read into the admission of other defendants. Therefore, the case cannot be decided on the basis of admitted facts. Otherwise, it has to be
So
decided.
it will not be entirely ignored as well, Lordship.
No, they have taken a stand. They have taken a stand. It is just a stand. Plaintiff says that there has been no partition. Some of the defendants say that there has been no partition. Some of the defendants say that there was partition. Simple. But the suit cannot be decided on the basis of admitted fact by the parties. If all the defendants would have said that there was a previous, the property is joint, then the court had no option but to partition.
Yes.
But if some of the defendants say that there was no partition, some say that there was previous partition, then the court has to look into the evidence and find out as to whether there was any previous partition. That's all?
Those were the two substantial, which was really lengthy.
It is little. But at least the fine distinction between Muslim and Hindu law, which I can say that many of the advocates might not be knowing, you must have learned during this time.
Yes.
And Mr. Zani, Sara Mountain law. Yes, you respond. How do you distinguish this judgment?
Yes.
This one, which says that this principle is applicable to 1993-1 PL.
93-1, yes.
Yes.
But let us see this judgment first, 93-1.
Yes.
But kindly take note paragraph 6 first.
Okay.
The facts are absolutely different.
Facts may be different.
Yes, note why I say this, because here note there was a suit, earlier suit 57 of 1952, in which the properties which were jointly recorded were already partitioned, and there was subsequent suit which was filed with respect to the properties which were only recorded in the name of defendants. And therefore, notes, in this case,
This was not the sole reason to decide the case in a particular.
no, notes, this was one of the consideration because in earlier suit, जहाँ पे property joint था, that was partitioned.
पहले दो तीन चीजें.
Yes, notes.
Is oral partition permissible in modern law?
But oral partition is permissible under Mohammedan law. But a person who says that there has been partition, he has to prove beyond all reasonable doubts that there was partition, which was acted upon by the parties by leading evidence and by, say, I can say not a legal aspect, by conduct of the parties. Because oral can't be proved not otherwise, because there is no document as
When
such.
we talk about conduct of the parties.
Yes,
So this principle
yes,
that there can be an oral partition,
yes.
and then the person who pleads that there was an oral
Oral
partition,
partition.
it is for him to prove that there is an
Absolutely. On
oral.
this,
The same principle is applicable for Hindu law.
for both laws.
For both?
Yes, because it is evidence act.
Okay.
101, 102, there is no distinction.
There is no distinction.
But on that principle, there is one judgment note of Supreme Court. But this is 2007, volume 4 SCC, page copy. Page 163,
2007,
volume 4 SCC, page 163, paragraph 17. Para 17.
Yes.
And just place the principles. हम इनको साथ ले गए
Para number 16.
17. In law there exists.
Yes.
Yes. In law there exists a presumption in regard to continuance of a joint family. The party which raises a plea of partition is to prove the same. Even separate possession of a portion of a property by a co-sharer itself would not lead to presumption of partition. Several other factors are to be required to be considered thereof.
It was
Yes.
continuation of joint family. Joint family is absent in Muslim law.
Joint family is absent in Muslim law on the premise that let us see, because here we are dealing with a Muslim law concept. With respect to few properties, which are admittedly in the name of common ancestor, which is joint, and few properties which are in the name of defendant, which is not joint.
That's
The court below says that since it is recorded and all the aspect being considered with respect to the properties which are recorded in the name of defendant, we are now only considering the properties which are recorded in the name of common ancestor, that is joint.
that's
So therefore, saying this that joint family is not recorded, accepted this principle in Muslim law, not father के नाम पे property है, then whatever right he gets, I also get. Then the concept of jointness with respect to other khatas, I am not saying. With respect to the khatas which is recorded in the name of common ancestor will definitely come into play because that is recorded jointly. So saying this that joint property, joint concept, family of jointness is not there. In these khatas, the concept of jointness will definitely come because it is in the name of common ancestor. Until today, the Jamabandi is common, rent is being commonly paid in the name of ancestor. So therefore, it can't be said. Definitely not with respect to other khatas. If I would have been arguing that it was acquired during lifetime of father, and therefore a concept under Hindu law that it was purchased by a joint family fund or nucleus coming out of the joint family fund, then I would have understood that my case that the concept of jointness will not come into play with respect to other khatas. But here with respect to these three khatas, the concept of jointness will have to come into play because it is recorded in the name of common ancestor.
the question of law is whether such inference which is available under Hindu law
Yes.
is available to Mohammedan law also.
Yes. Yes.
So the contours of the question of law is, suppose it was a case decided under Hindu law,
Yes.
then the judgment is correct, right? But if it is seen from the angle of Mohammedan law, whether the same principle will apply.
Whether same principle have been applied.
Now, which is that principle which will not apply to Mohammedan? Which amongst this oral partition is available, right? It is to be proved by the party who alleges there was
partition.
So
Exactly.
these are common principles of Hindu law and Mohammedan law.
No, not so.
Which is that principle which will not be applicable?
But if I may say so, the question of law is whether the inference drawn by the learned appellate court, that is because trial court decreed the suit. So inference what is being drawn by the appellate court in deciding this appeal,
Yes.
relying upon the concept कि हिंदू लॉ में क्योंकि separate cultivation में है इतने साल से है, इसीलिए that concept if is available under Mohammedan law. So not I say this that here on basis of this documentary and oral evidence, because documentary there are only two exhibits, exhibit D and D by 1, but both those documents does not refer to any previous partition. The judgment which was cited relying on the sale deed aspect notes, this is Patna, 71 Patna also your lordship may take. Why this will not be applicable in this case? That's not Arjun Mehta's case.
Yes.
But kindly take paragraph 20. The lordship has seen paragraph 25 which they read. Paragraph 20. Where place this person? Exhibit K Ka 1 is the sale deed executed by Nitai Mehto, plaintiff in favor of Jhabu Mehto, defendant number 9, containing the statement that his father got the land partitioned privately and orally, and on his death he has inherited the property left by his father. Therefore, the sale deed recites that there was partition and my father got that property, and on basis of inheritance I got after my death, after my father's death. So therefore, that sale deed only recites that, and then that concept the court said, since that sale deed recites of previous partition, which was accepted by the plaintiff, executed by the plaintiff, therefore the plaintiff cannot retract from that statement now. But so far as 36 Patna is concerned, which was the first judgment which your lordship said, I read yours. But this your lordship will also see. Here also, I'm sorry, 36 Patna. This is Mukram right. Yes. Here also note first paragraph itself only. The appeal arises out of a partition suit in which the district judge of Sahadabad has upheld the decision of the trial court and dismissed the suit with regard to bulk of the properties sought to be partitioned and decreed the suit with regard to those properties which were admittedly held in common. Here also, note suit with respect to other properties which were not held common was dismissed, but the properties which were in common were decreed, and that was the judgment upheld by the court. Here note, I also say that so far as other khatas are concerned, I am not arguing that 36, 11, 110, which were admittedly joined. This was the judgment, and this district judge judgment was upheld by the court.
No, the court had partitioned the property,
Yes, not
which was
jointly.
joined.
Yes, joint. So I also say not joint because common ancestor, it is joint. It is nobody's case.
With respect to common ancestor, there was a clear previous partition.
Sorry, what?
With respect to the properties belonging to common ancestor, there was a clear previous partition.
Not bulk of the properties sought to be partitioned
Yes.
were dismissed and decreed the suit with regard to those properties which were admittedly held in common. So therefore, the properties yes, not. The parties are admittedly descendants of common ancestor Gandhu Rai, who had two sons Sampath and Visesar. The plaintiff and the descendants of the Visesar and defendant are the descendants of Sampath. The plaintiff's case is that they and the descendants were co-partners of the joint family governed by Mitaksha school, and the properties sought to be partitioned were all joint family property. The defendant, on the other hand, contended that there had been disruption of the family long before the institution of the suit, and that the properties had been partitioned some 90 years before the suit. So here notes, this was the case that some properties recorded jointly, some properties recorded in common ancestral name. But the suit was dismissed with regard to properties recorded separately and decreed with respect to the common properties. That was the fact of this case. And this judgment of district judge was upheld. Ultimately, notes the appeal was dismissed. So the court, while not deciding the first appeal, got persuaded in my humble submission with respect to other khatas which were recorded in their name, defendant's name, and dismissed the suit with respect to the properties which were recorded in the name of common ancestors.
You see, I want to know
Yes.
that this principle
Yes.
of drawing an inference
Yes.
that there was a previous partition, what is the distinction between Hindu law and Muslim? Is there any distinction?
Not
Or there is no distinction? If there is any distinction, you
Yes.
point out that distinction. Because that is the substantive. Whether this principle of Hindu law, which is applicable, drawing inference
Yes.
of previous partition on the basis of conduct of the parties, is it applicable in non-Muslim?
But I have not noticed, my senior would always definitely correct me if I am wrong, but I have not gone through any of the judgments which says that so far as drawing inference with regard to this concept, there can be any distinction between Hindu or Muslim law.
If there can be no distinction,
Yes, please.
then under such circumstances, this court will have no option but to hold that the same principle applies to the Mohammedan law also.
But therefore I say,
Therefore,
Yes.
there is one more sentence
yes,
to it.
yes.
Therefore, the findings of fact which has been arrived at by the learned first appellate court by referring to this principle,
Mhm.
that is not the question matter. That is not the matter of dispute under in this that finding. That is why I asked you, had it been there are two things. Whether by applying this principle the court has rightly come to a conclusion is another concept altogether, another question altogether. The question is whether this is applicable or it is not. Once it is held to be applicable,
Yes.
and the appellate court has come to a conclusion on the basis of these evidences, that finding cannot be assailed.
No.
By referring to this question, there could have been a different question of law, that whether on
But
the basis
I
of
am Lord, if I get your lordship correctly, Lord, that your lordship is saying that so far as answering this question, that whether the inference of Hindu law and Muslim law, with respect to this
Previous
partition, the inference and the principle will apply or not. This is the question, and if another question would have been formulated that whether the judgment of the appellate court in drawing an inference with regard to considering these documents, oral and documentary, is vitiated, that would have been another question. But not that question, was in my humble submission, would definitely not be covered, because your lordship will have to confirm this.
You see, the court has applied a principle of law.
Yes. But
Whether that principle is applicable in the Mohammedan law or not is the question of law.
In my humble submission, what's
And
the
once it is held that it is applicable in Mohammedan law, then the court has applied its mind.
no? But I only say this that your lordship will see. Not it is.
May I take leave, Lord? Another case is going.
आप permanent जा सकते हैं.
But I say this that the
लेकिन ये अच्छा बात नहीं है.
Lord, the one matter is going.
वो नहीं है. ऐसा second appeal first appeal ऐसे नहीं चलता. आपको किसी आदमी को वहाँ पे रखना चाहिए. When you are in the midst of the matter. Yes.
But I say this that the inference has to be read into that what led to the court to draw that inference. It can't be
That
not
is not
shut.
the substantial
No,
question.
it can't be not shut. That your lordship will not shut your lordship's eyes, but only say by because inference has to be drawn on basis of something.
You see, that is not the substantial.
But then I can only say that if during
If you would have convinced me that this principle is not applicable in
but
modern law,
I very fairly not
it
I
is-
have not
apparently it is not possible.
I have not
also.
read anything which is contrary to Hindu law. The concept is definitely somewhat different. That there is no joint concept. Those are different things. But I have not read anything till now in my whatever.
तो second appeal में substantial question of law थोड़ी second law का बनता है.
But in my research also I have not gone through that anything. But not, I have two judgments also. Because this conclusion of the appellate court only on two aspects is not apparently not correct with respect to these three khatas. Because how can not the court say that let me assume a broader picture. I live in a joint family property. I am living my other brothers and whatever my relatives are living as per their convenience. Can't I sell not my property? Being a co-sharer can definitely sell his property. There is no dispute on this proposition of law.
Co-sharer can sell his undivided
Yes,
portion of
definitely.
But the co-sharer will not sell a definite share of the
But
property.
he can, because the sale deed can't be vague. The sale deed can't be vague. I can't say that I am selling my 1/3 of half share in my residential house. A sale deed has to be definite.
Given the question of law,
Yes,
you are stretching it too far.
but
Because then this will you are drawing the court to then reappreciate the materials and whether the principle has been correctly applied, although the principle is common in Hindu law and Muslim.
yes.
So that is not the
But
scope.
therefore, if your lordship will feel that this question arises
No,
here
it does not
after,
arise.
but this question
It
that
does
whether
not
this
arise.
consideration
You
is
see,
correct.
No, that is not. We are not on that. We are not going to frame additional substantial.
No,
questions.
no, I only say this that this question will definitely not what I'm trying to
We
argue.
will not widen the substantial question.
Lord, your lordship will see.
After
Therefore,
hearing it for 2 days.
no, therefore it says, Lord, the plaintiff and defendant are oral and documentary evidence.
Yes.
Because the inference has to be drawn on something or the else.
Inference has been drawn on oral and
Yes,
documentary
therefore
evidence
I
by applying a principle of law.
Yes,
Whether that principle of law, which is admittedly applicable in Hindu law, is applicable to the Mohammedan law also. or
but
not.
therefore let me.
And once it is held that it is applicable in Mohammedan law, it's full stop.
But therefore it has to be seen that.
Nothing. The same principle is applicable. The court has taken into consideration the materials on record, oral and documentary, and come to a conclusion.
But therefore the inference which is being drawn, whether that is correct or not.
That is not the substantial question.
But therefore I
We
say,
will not
Lord,
stretch it beyond this.
so therefore I say, Lord, that your lordship will appreciate this. Lord.
I am bound by law, you are not.
No, Lord.
You have more freedom than me.
The Lords have both sides experience, so I can't say on that, Lord. But your Lordship will see, Lord, whether that inference is to be drawn, what is being drawn by the first appellate court, is correct or not. Your Lordship will not shut your Lordship's eye if the inference is drawn absolutely not correct, and then your Lordship will say, because this question of law has to be answered in this way, then your Lordship can answer this, that whether this principle of Hindu law can be made applicable.
I will only answer that.
Only that, Lord.
I will only answer that.
But
I'm not supposed to answer more than what is
therefore, your
required.
Lordship.
अगर हम आपसे सिर्फ आपका नाम पूछेंगे तो आपको अपने पिताजी का नाम साथ में जोड़ने की कोई रिक्वायरमेंट नहीं है।
लेकिन हम ये नाम खाली पूछना हम लोग, लेकिन इन्फ्लुएंस जो है, ये जो इन्फ्लुएंस का जो कॉन्सेप्ट है कि ये कॉन्सेप्ट क्यों आएगा, तब देन तो आई कैन से कि द कॉन्सेप्ट ऑफ जॉइंटनेस in a Hindu law and the concept of jointness in Muslim law is absent. Therefore, the both principles will not be applicable.
आप बहस करिए, आपको बोल ही रहे हैं, आपको आप अभी तक तो यही बहस कर रहे हैं। अभी आप
हाँ,
क्या
हाँ,
बहस
बस,
किए?
हाँ।
Oral partition is permissible in Mohammedan law, admitted, right?
Yes.
And the only thing is that it is to be proved. Simple. And
Yes.
how is it to be proved? It has to be proved by reference to evidence law.
Lord, may kindly see this. Lord, I have noted, Lord, what is the difference between Hindu and Muslim so far as partition is concerned.
बताइए,
Yes.
क्या बोले?
Lord, there is a difference of presumption of jointness. In Muslim law, there is no presumption of jointness. And so far as in Hindu law, there is a concept of joint family. Lord,
नहीं,
Yeah.
ऐसे इसको लिखते हैं कि
हाँ.
Muslim law there is no concept of
a joint family.
unity of title.
Yes, unity of title is can.
But there is concept of unity of possession. यही fundamental फर्क यही है. There is no
Fundamental-
concept of unity of title.
And not one more fundamental difference is that in Muslim law, when the father dies, then not the properties would the legal heirs will get a right. That is on death. So far as in Hindu law is concerned, it is the birth right.
That's right.
So Lord, here your Lordship will see that here if it is the case of the parties that there was previous partition after death of the father, then that has to be proved. Here, Lord, there is
That
no.
can be proved by conduct.
Therefore, I say, Lord, conduct in what sense? Conduct, Lord, only by executing two deeds, which does not refer to any partition, which does not say that I have been granted this property in partition and I am executing a sale deed. This is one. Second, the evidence.
नहीं, the deed says that they are the exclusive owner of the property.
But if I am executing, not a co-sharer is also an exclusive owner. Co-sharer is also an owner of the property.
No, there is no concept of unity of title.
No, by concept unity of title, once the father was alive, but both of us can't have any property. Once the father dies, then the property will definitely devolve upon both of us.
Still there is no concept of unity.
No, after death.
Even after death there is no concept of unity of title.
But so far as
In Mohammedan
property
law.
of father is concerned, that so definitely will.
No. Each one of them
Yes.
get definite share
Definite share.
with respect to every property.
Every property, therefore, every property will be held to be co-share. Every property, I will have a definite share. They will have a definite share. So therefore,
Everybody will have a definite
definite
with
correct.
respect to every property.
Huh?
Yes.
So every property. Therefore, I say, Lords. Therefore, the point of this common joint property will definitely be there with respect to after death of father. In 40, what is being said that the plaintiff and the defendant will have a definite share in each of the properties. It is not that this property will be of plaintiff, this will be of defendant, like in the case of partition. But every property, I am also owner, he is also owner. So therefore, Lord, being a owner of a property, a co-owner of a property.
Co-owner of a definite sharing property.
Yes, so I can sell that property. There is no dispute on that legal proposition. So, if I sell a property, being a co-owner of a definite share, can it be said that there was partition where in the facts and circumstances of a case where
मेहनत हमको लगा है आपको इस पॉइंट पे लाने के लिए हम ऐसा सोच के आए थे कि आप बहस करेंगे
हम ये नोट करके लाए थे but your lordship took me on a different aspect of question of learned because this note I noted notes 2 days back while preparing myself. Okay, what is this? So therefore, I have the judgment which says, oh, I place that judgment
नहीं
on.
पहले तो आपको दोनों का डिस्टिंक्शन पहले तो आपको ये होल्ड कराना पड़ेगा कि that there is a difference and whether there is a difference or not. This is something which has to be decided.
So therefore, Lord, I am saying that once does this aspect that I being one of the co-owners of a definite share can sell the property, there is no dispute. Given the fact that there is no admission on my part in the sale deed recital thereof that there was partition. So that was considering exhibit D in my humble submission notes in dismissing my suit so far as these 3 khatas are concerned is not. Lord, receive not one judgment, but on the Muslim law itself. Here notes the suit for partition was filed, the suit was decreed, title appeal notes reversed the judgment, and second appeal notes allowed, restored the initial decree and granted. But can I place this one?
Yes.
Yes. But paragraph 2 that the facts. The plaintiff appellant filed a suit for partition, alleging that the plaintiff and the defendant number 1 to 4 are real brothers and they were living in the house, which was owned by the father Nader Ali and being occupied jointly by all the brothers. Subsequently, a new house was constructed by the father in which the plaintiff and 3 brothers, including defendant number 1, started living in that house and one of the brothers remained in the old house. Upon their father's death, the plaintiff contended that each brother claimed to occupy a portion of the house as per their convenience and there was no formal partition of their shares in the property in dispute by metes and bounds. Consequently, the suit for partition was filed. The defendant number 1 registered the suit and contended that there was previous partition on basis of which each of the brothers occupied their share of the property in question in which they were living along with their families and consequently there was no need for any further partition. And defendant number 2, 3, 4 filed a separate written statement and contended that there was no formal partition by metes and bounds though they were living in separate portion as per their convenience. During pendency of the suit, defendant number 5, 6 and 7 were included who were contended that they were original owners of the owners and the plaintiff and defendant number 1 to 4 were original owners and the plaintiff and defendant number 1 to 4 were their licensing. The trial court, after framing issues and after considering material evidence available on record, decreed the suit, holding that father of the plaintiff and defendant number 1 to 4 was owner of the house in question and upon his death, the property devolved in equal share upon plaintiff and defendant number 1, 2 and 3 and 4 and defendant number 5, 6, 7 were not the owners of the house or nor had they given the house to the father of the plaintiff and defendant as a licensee. The trial court further held that there was no previous partition by metes and bounds and the plaintiff and defendant number 1 to 4 were occupying a portion of the house as per their convenience and as such convenience was not in pursuance of any mutual or private arrangement nor there was any property partition by metes and bounds. Consequently, the suit was decreed holding that the plaintiff was entitled to 1/5 share in the property. Agreed by the defendant number 1 filed appeal, which was allowed and the degree of trial court was satisfied, the suit was dismissed. The lower appellate court held that there was private arrangement between the plaintiff and defendant, on the basis of which each of the brothers were occupying portion of their house in question and came to the conclusion that there was a previous partition and consequently held that a suit for partition was not maintainable and dismissed the suit. The plaintiff being aggrieved by the decision of the lower appellate court has filed the present second appeal, which was admitted. Now, whether the lower appellate court was justified in accepting the private partition without there being definite evidence regarding share. Upon hearing the counsel of the party and perusing the case record as well as the judgment of the court below, this court finds that the lower appellate court cannot be sustained. The conclusion drawn by the lower appellate court that there was previous partition between the parties is incorrect is solely based upon report of Advocate Commissioner who reported that the parties were living and occupying separate portions of the property in question. In my opinion, this is the report itself would not lead to conclusion that there exists a family partition at some anterior point of time based on which the parties came in possession of the share of the property in question. No evidence of any sort has come in court to show that precise share were allocated to each of the brothers. In fact, the evidence of plaintiff one indicates that there existed three angas in which one was being utilized by two other brothers. If the parties are in occupation on basis of their convenience, and are in possession of certain portions of the property, this by itself would not make such possession to mean that there was previous partition. To put it more clearly, a partition by way of convenience of possession of certain portions of property by itself would not come in way of any degree of partition, especially when the property has not been divided by meets and bounds. Consequently, assuming that there was a family of private arrangement on basis of which parties were occupying their share of portions in house in which in question by way of mutual convenience will not amount to any partition by meets and bounds between the parties. And therefore, Lord, sir.
That's now how do you respond to your sayings?
Yes. But I respond to my sale deed saying this, Lord, that even if once, Lord, I am a co-owner, I can execute in law with respect to the property of which I am a co-owner. If there would have been an admission, I am not assuming this, that if there would have been an admission of any previous partition, accepting that this property was given to me in partition, then I could not have retracted from that sale deed because it was a registered document executed by me itself. But here in this case, that aspect that I got this in any partition, mentioning that there was a previous partition and I got that property, that will not come into my way of partition with respect to these three khatas. Because
do you want to say that in every property you have your own share?
Yes, I have a
definite share in every property.
Definite share in every property. Even they have a definite share in every property. After death of
if there are 10 houses, you can have definite share in all 10 houses.
All 10 houses. This I don't see not any.
Mutual adjustment is a different thing.
Mutual adjustment is a different thing altogether, but that is as per convenience because.
So merely because two of the properties have been sold by indicating that you are selling 1/3 of your share.
Yes,
by itself does not indicate that all the properties have been
partitioned.
Yes.
Coupled with this fact, just yes.
You wanted the share in this property also?
Sorry?
During partition? You wanted a share in this property also?
This property, the other
property. Which you have sold?
Sorry?
Which you have sold?
Yes.
You wanted a share in that property also?
But since I have sold, that was not included in the suit itself.
That property was not included?
Not included.
That saying was not, that particular plot number was not included in the partition?
I guess it was not included. Because the judgment says so.
Included or not included?
Not included.
Not included.
Not included.
Therefore, referred partial partition.
Yes, yes. आप बताइए सब partial partition भी बताइए.
Yes.
हम hold किए कि partial partition is permissible under Mohammedan law.
According to that argument advanced by my friend, they are asking for partition with respect to certain land.
Yes.
Not with respect to the entire land which they have ceded.
That's
Therefore, it is the issue involved with the trial court also. That is issue number. But no question has been formulated in this. Therefore,
issue number 7.
Answer in that 7.
And since no question has been framed, therefore I need not answer.
No question. Yes. Therefore, I did not insist.
And that has been decided against.
Yes. Now, from the argument advanced.
Not from the argument. You see, we are just examining. Here is we are examining the parallel between Hindu law and Muslim. when it comes to application of the
Yeah.
principle. Right? Under the Hindu law, there are various circumstances where the previous conduct of the parties can be taken into consideration to say that there was a previous partition. But here in case of Muslim law, in order to get that there was a previous partition, merely because with respect to some of the properties there has been sale by the plaintiff, that will not give an inference that the entire property has been sold, has been partitioned. That inference cannot be drawn in Muslim law because of the reason that under the Muslim law there is no concept of unity of title.
Not.
Every piece of property
Yes.
is subjected to partition.
Yes.
So if one of the property is sold or a share in the property is sold, then at best you can assume that there was a partition with that property.
Yeah. Therefore, Virat,
You cannot say that there was partition with respect to all the properties.
the word presumption is word of evidence act. And the evidence act is applicable in case of both Hindu and
Yes.
non. And it has been thoroughly dealt with by the appellate court. That same presumption will apply in case of Mondan also.
It will not. The contours, the presumption would be there, but the contours of presumption will be very, very different. Merely because for one of the property there has been execution of sale. You see, there are 3 circumstances. One is that the rent is still being paid joint. All of you are paying the rent joint. There is no mutation amongst yourself. You are possessing the properties individually in whatever manner you are. That finding is there, that you are separating mess, you are separating cultivation, that finding is there. And there is a finding that because there is sale qua one of the properties, which is not a matter of subject matter of partition also. Therefore, it is being presumed that there was partition for the entire.
Yes.
See, that presumption is too far. That presumption is too far. Similar, this kind of presumption could have been there. This kind of inference could have been there under Hindu law. But when it comes to Muslim law, since every property is to be partitioned and everybody has equal share in every property, then under
Equal, not equal, definite share.
definite
What-
share,
what
not
is
equal, definite share in every property. Then under such circumstances, that is why in one of the first appeals I held that only one property was subject matter of partition. A plea states that partial partition is not permissible. In that case, I have held that since everybody has equal share with every property, a person can go for a partition of one.
Therefore, Virat, I submitted that they should have come with the specific land for partition.
They have
Sake of no, the entire, therefore,
plot number etc. is there.
plot number is there, but with respect to the khata number,
Yes.
I am submitting with respect to khata numbers. Now in argument that they are coming to only the land recorded in the name of Sheikh Father.
Yes.
Though they have asked for other lands also.
That has
Which
been,
one?
that those are all segregated,
So
held
why
to be
submit-
self-acquired property.
Therefore,
That is not, it has not been held that they have got it by way of partition.
Therefore, yesterday I have submitted that partial partition is not maintainable in case of modern law.
We need that.
Yes. For a six, yesterday, maybe Supreme Court will tell me.
Allahabad High Court.
इलाहाबाद ओ अच्छा इलाहाबाद वो पुराना पैराफाइट एंड आई एम अच्छा ठीक
हम लोग खान साहब के साथ
नोट करें
एनएम साहब के साथ पढ़ते हैं अपने
May I take help of my friend?
Yes.
The plaintiff's case is that only the middle portion of the building was liable to be partitioned because in respect of other two portions, it was stated that the said portions had been gifted away in favor of respondent 4 and sold in favor of in the favor of plaintiff respondents. The partitionable property, according to the petitioner, was only the middle portion of the house. Whether the whole building was liable to be partitioned would depend on the fact as to whether the defendant petitioner would succeed in proving that no sale or gift had taken place, or conversely, if the plaintiff would fail in proving that the sale or gift in favor of respondent number 4 had taken place. In that case, whole house is liable to be partitioned. But unless that plea was inquired into, the suit would not be barred on the ground of doctrine of partial partition. This is a doctrine which bars trial of suit for partial partition in certain circumstances. If the court trying the suit is satisfied that the entire property liable for partition was not included in the suit and only a portion of the property sought to be partitioned, it would decline the relief of partition. It presupposes that the whole property must be capable of partitioning, and if a party applies for partition in respect of a portion of property and leaves out the other portion of property, such a suit will not be maintainable.
See, the entire partition in this case with respect to one building.
Yes.
So that kind of partial partition is not possible. But if there are different plots, there are different areas.
The
And
property has been included with respect to khata number, including plot numbers.
that's right.
And
And that property which has been sold has not been included in the partition.
In the partition.
That has been completely excluded.
Excluded.
Because plaintiff was apparently conscious of the fact that he doesn't have any right
Yes.
over those properties, he has already sold it off. Consciously not included.
But a specific issue was raised, therefore I submitted the
Yes. Which is that issue?
issue number 7. इसका पार्टी
Issue 7 was whether the plaintiff's suit is back for partial partition, that is to say for not including plot 120, 1231 and 1236 of Khata 36 of Village Tige Ambadli.
The property has been sold in these properties?
Yes, Your Lordship.
Where is the answer?
Starts from para 19, Lordship, next page. That's right.
Where is the conclusion?
But the conclusion is para 39.
हाँ 39.
और ये कहाँ?
Perhaps page 48 or para 39.
Para. Okay.
Page 48 पे para 39.
These plot numbers 1231 and 1236, which were admittedly Sahar and Makan in possession of Sheikh Charku, the plaintiffs. And since the time of record of rights to which the defendants have also not denied, but his possession is nothing but on behalf of his father, the said father, the recorded tenant. So these lands are also liable for partition. But since the plaintiff and the fathers are living and in possession of this Makan and Sahar since long, therefore on partition it may be allotted to their share.
And already sold.
This was already.
Then they are in possession. Till the date of it, they are one.
That's right.
But they've sold.
And
This is the property which was sold.
Yes,
on
yes,
the
1231, 1236.
इसी में sale हुआ
हाँ,
है?
इसी में से.
Are you
इसी में
sure?
से
Yes,
पता
sir.
कीजिए साहब. And that has been dealt with by the appellate court. ठीक है.
हाँ वही 1231, 1236.
नहीं continue.
नहीं ऊपर देखिए partial partition तो यहाँ पर पैरा नंबर. The plaintiffs have not included these two plots in the list
their partition and so the
on
defendants
the
are
partition, so the defendants are challenged their case on the ground of partial partition. But it is a fact which cannot be denied that on account of non-inclusion of one or two items of the property or the plot of land, the case of the plaintiff cannot be proven.
But this is not the correct law dealt with by the trial court.
Anyways, but partial partition का issue है नहीं.
नहीं यहाँ नहीं है therefore it is submitted इसीलिए हम उसको छोड़ दिए
अब थोड़ा लिखते हैं.
Seek judgment for the latest in 2025.
हाँ? बताइए.
हम कॉपी कर आगे नहीं हम कॉपी लाए आपके लिए
अब देखिए क्या करते हैं.
Para 17 and 27.
The flow of the dictation will ultimately decide. Para
17 and 27 was the proposition that livings as per convenience does not mean partition. With 25 Lata they found out. Seventeen and 27. Huh?
But is
Yes.
it is settled proposition.
It is settled proposition that when a claim of oral partition is made, the burden is on the party setting up the claim of oral partition, and the burden is on onerous and ought to be discharged by letting in cogent evidence. Merely living separately by the plaintiff and second defendant does not exclude the co-owner from the right to joint possession. The law presumes that all co-owners are in joint even if they are not physically present and actively managing the property. It is relevant to mention that a mere arrangement as to the possession of convenience of the parties is not partition by metes and bounds. Such amicable arrangement can never be operative and binding for all times to come, and such arrangement does not destroy the joint character of the properties. Numbers para 27. It is settled law that mere separate enjoyment for convenience cannot be equated to partition in the eye of law. It does not mean joint ownership has been put to an end and in its place ownership in severalty or in specie has come into existence. Separate enjoyment for sake of convenience is one thing and partition is another in the eye of law. There has been some further evidence in support of partition. A division bench of so and so has explained the concept of partition as it would be worthwhile to refer to the same. So, both these paragraphs say that living separately as per convenience, it is settled proposition, does not mean partition.
इनको जो रहेगा कागज देंगे आप जो जो जजमेंट्स डायरेक्टली हैं आप लिस्ट बना दीजिए आप लिस्ट सिर्फ एक बार लिस्ट दिखाने दीजिए.
बट सर तो जो तीन जजमेंट बोले वो तो अपलेट कोड क्या है और एक और हम दे. But should I write down the proposition also on which it has been judgment?
If you can by the time I give dictation. Second appeal number 85 of 1994. This appeal has been filed against judgment dated 11/4/1994, within bracket decree dated 25/4/1994 by the first additional judicial commissioner Tanti, entitled appeal number 35/3 of 1988-89, whereby the learned first appellate court has reversed the judgment and decree dated 5/5/1988, passed by learned 6th subordinate judge Ranchi in partition suit number 146/114 of 1982-87. The learned trial court had decreed the suit and has declared plaintiff's 1/5 share to be carved out and allotted to them by appointing a pleader commission. The first appellate court, while reversing the finding, has recorded that there was previous partition with respect to Khata number 36, 11 and 110, which stood recorded in the name of common ancestor Sheikh Paga, and with respect to Khata number 80, 88, 89 and 90, the learned first appellate court has recorded that it was the self-owned and self-acquired property of the concerned defendants in whose name it was recorded. Correct? This appeal was admitted for final hearing by the order dated 16/8/1995. So quote करेंगे. It further appears that an additional substantial question of law was framed by this court by order dated 24/9/2025. As follows, quote करेंगे. Whether in spite of clear-cut admission of the defendants in the written statement filed by defendants, admitting that land of Khata number 36, 11 and 110 are joint family property and liable for partition, the suit for plaintiff would have been dismissed. However, the additional substantial question of law framed by the order dated 24/9/2025 was modified by order dated 14th of October 2025 with the consent of the learned counsel for the parties, inasmuch as the clear-cut admission with respect to Khata number 36, 11 and 110 being joint family property was only in the written statement filed by defendant number 1, 9 and 10 and also defendant number 1A and 1C. And consequently, while the order dated 14 October 2025, the substantial question of law framed by order dated 24/9/2025 stood modified to be read as under. Para 4 में है. Thus, the two substantial questions of law which has to be answered in the present case are follows. दो करेंगे, एक 16/8/1995 का और एक 14th of October 2025. During the course of arguments, it is not in dispute between the parties that Sheikh Paga was the common ancestor. who died in the year 1940. It is further not in dispute that he is the common ancestor of the plaintiffs and the defendants, but not that of the intervener defendants. Intervener के तो नहीं. It is further not in dispute that Sheikh Paga had 2 wives. And the plaintiffs were representing the Sheikh Paga has 2 wives, and from his first wife he had a son namely Chakru, Sheikh Chakru. Charpu. And the plaintiffs were sons of Sheikh Chakru. So far as the second wife is concerned, he had 4 sons through the second wife, and the descendants through second wife were the contesting defendants.
Yes.
Contesting defendants in the
Not
suit.
all, because contesting is defendant number 2 to 8. Not all.
बाकी खाता में तो है ना, तो contesting है ना, ठीक है, बाकी खाता में तो है।
Okay. So far as the second wife, the descendants through second wife is concerned, they were the defendants in the case.
So defendant 1 to 10 are the descendants of second wife, and 11 to 14 are the interveners.
Okay. Defendant number 1 to 10
Yes.
are the descendants of the second wife
Yes.
through the second wife,
Yes.
and defendant number
11 to 13.
14.
14, yes.
11 to 14 were the interveners.
11 to 13.
11 to 13 were the
are the
interveners.
interveners. Yes.
It is also an admitted fact that at the time of death of Faga in the 1940, he left behind his 2 wives and 5 sons. Who were the heirs and successors of the property left by Sheikh Faga, as per their respective shares in accordance with Mohammedan law. It is further not in dispute that the share of 2 wives together could be 1/8 in his property, and remaining would go to his 5 sons. And there was further no dispute that all the heirs of Sheikh Faga were tenant in common with respect to the properties inherited upon death of Sheikh Faga. It is further admitted that both the widows of Sheikh Faga predeceased their respective sons, and as such, the share of each widow stood inherited by their respective sons. In view of this, the position stood admitted regarding the genealogy of the parties to the suit and the property of Sheikh Faga and his two widows would come to Sheikh Chakru to the extent of 23.6%. ये लिखा हुआ है
Judgment में
in the property of Sheikh Faga and remaining 76.4% in the share of the four sons of Sheikh Fagu born out of his second wife. It was further not in dispute that Khata number 36 stood recorded in the name of Sheikh Faga and four other persons and in the remarks column, plot number 398, 1066, 1067, 1068, 1250, 1686, 1687, 1231, 1236, and 1211 of Khata number 36 stood recorded in the possession of Sheikh Faga. And the remaining plots of Khata number 36 stood recorded in the name of other co-tenants of Sheikh Faga. Amongst the various properties, plot numbers which were recorded in the name of Sheikh Faga, plot number 1231 and 1236 of Khata number 36 were not included in the suit property. And plot number 1250 was also deleted from the schedule of the property. Subparagraph. Khata number 11 also stood recorded exclusively in the name of Sheikh Faga, which consisted of only one plot of area 1.6 acres. Semicolon. Next subparagraph. Khata number 110 stood recorded in the name of Sheikh Faga, which consisted of four plots having 3.14 acres. So far as Khata number 80, 88, 89, and 90 are concerned, they were recorded in the name of defendant number 2 and 328, comma, defendant number 1, comma, 2 and 3, 2, 1, comma, 2, and 328, comma, defendant number 1 to 10, and defendant number 1 to 10, and defendant number 11 to 13 respectively. Considering the arguments advanced with respect to the substantial question of law, the finding in connection with Khata number 80, 88, 89 and 90 that it was the self-acquired property of the various defendants has attained finality, and the same is not the subject matter of consideration in this appeal. this court is only considered with khata number 36, 11 and 110, which stood recorded in the name of common ancestor named Sheikh Father. It is further not in dispute that these khata numbers still continued to be recorded in the name of Sheikh Father, and the rent with respect to these properties was being paid jointly by the plaintiffs and the defendant number 1 to 10. At the same time, it is also not in dispute that 2 sale deeds were executed by the plaintiffs, which were Exhibit D and D by 1, which were related to khata number 36 and in the said sale deeds, the plaintiffs had sold 1/3 share of the concerned plots, and those plots were not included in the schedule of the partition deed, partition suit, meaning thereby the properties in connection with khata number, which were subject matter of sale by the Exhibit D and D by 1, were excluded from claiming partition. Before the learned trial court, all the khatas, properties in all the khatas, including khata number, which were in khata number 36, 11, 110, within bracket recorded in the name of Sheikh Fagu, bracket close, and also khata number 80, 88, 89 and 90, were subject matter of the partition suit, in which the following issues were framed. Para 17 of the trial court judgment. Issue number 3 was not pressed. Issue number 4, 5, 6, 7, 8 were taken up together. And it was the specific case of the defendants inter alia with respect to khata number 36, 11 and 110, that after death of Sheikh Faga in the 1940, there was an oral partition and the plaintiffs got share in the land of khata number 36, whereas rest of the ancestral properties were allotted to defendant number 1 to 10. However, the dependent number one, comma 9 and 10, and also dependent number 1A to 1C in the written statement stated that khata number 36, 11 and 110 were joint family properties and liable for partition. But the other dependents took a specific stand of previous partition way back in the year 1940. Previous oral partition way back in the year 1940. The learned trial court, while deciding issue number 4, 5, 6, 7 and 8, ultimately held that the land recorded in possession in the name of Sheikh Faga under khata number 36 belonged to him. Semicolon. The land of khata number 11 and 110 also belonged to Sheikh Faga, in which the plaintiff claimed 1/5 share, and this relief cannot be denied. And ultimately held that property in khata number 36, 11 and 110 were the ancestral properties which were still not partitioned and both the parties used to cultivate the land according to their convenience. And therefore the defendants cannot have a case of ouster against the co-sharer, and the plea of defendant was rejected. The trial court also recorded that in the same deeds exhibit D and D by 1, which was sold by the plaintiffs, there was no reference of any previous partition. And it appeared that few distance of land have been sold by the plaintiffs out of the land to which they were cultivating for convenience. And was of the view that the same was not sufficient to hold that there was previous partition. It was also recorded that when the plaintiffs sold the property which was under their cultivation, with respect to some portion, it was natural upon them to mention that they were selling their share with respect to the property. It was held that merely because the co-sharer has sold portion of property, the same does not mean that there was any previous partition. And the reference was made to a decision of the Honorable Patna High Court reporting in AIR 1977 Patna 89. The learned trial court thereafter considered the oral evidences and observed that the lands were still joint and were not partitioned. With respect to the properties under Khata number 80, 88, 89 and 90, the learned trial court was of the view that the same was acquired in different names from the joint family fund. And was of the view that those properties were also required to be partitioned. The court was of the view that the family was joined and so the acquisition in the name of one or the other sons will not alter the position, and was of the view that the real title holder of the property was said father. With respect to plot number 1231 and 1236, in, the learned court also recorded that the plaintiffs had not included plot number 1231 and 1236, and the defendant had challenged their case on the ground of partial partition. The plea of the defendant was rejected, and the court was of the view that the property in plot number 1231 and 1236 were admittedly, in paragraph 939, were admittedly Sahan and Makan in possession of Sheikh Chakri, since the time of record of rights, which was also not denied by the defendants, but held that the possession of Sheikh Chakru was nothing but on behalf of his father, Sheikh Faga, the recorded tenant, and these properties would also be liable for partition. But since the plaintiffs and their fathers were living and in possession of this Makan and Sahan since long, therefore on partition it may be allotted to the share. The learned first trial court in paragraph 39 and 40 recorded the finding as under, and ultimately the entire property of khata number 36, 11, 110, 80, 88, 89, 90 were subject to partition. By deciding issue number 1289, the first appellate court held that the plaintiffs were entitled to their 1/5 share of the entire property. So far as the learned first appellate court is concerned, the following points were the point for determination. This paragraph,
But paragraph 14 notes page 21. Point 20.
the following points are the points for determination. Considering the concludes of arguments with respect to the substantial question of law, it is not in dispute between the parties that the point of determination for consideration in this, with which this court would be concerned, would be the point of determination number 1 and Roman 3 within bracket to the extent it relates to खाता number 36, 11 and 110. ठीक है? वो दोनों मिक्स किया हुआ है. The learned first appellate court recorded the findings from paragraph 15 First, dealing with the point number 1, the court recorded the admitted case amongst the parties and observed that the descendants of Sheikh Faga would were all tenants in common. The very first appellate court recorded that there was no documentary evidence in connection with previous partition. The court further recorded that the Jamabandi was still running jointly with respect to khata number 36, 11 and 110. The court also recorded that Exhibit D and D by 1 are the certified copy of the sale deeds executed by the plaintiffs. In favor of Sheikh Rahim with respect to portion of land of plot number 1066 and 1067 on 1/2/1974 and 6/2/1974 respectively, which was prior to institution of the suit. ये plot number आप जो बोले थे वो match नहीं करता। आप जिस plot number की बात की तो वो match नहीं करता। It is 1066 and 1067. यही दोनों plot का property है, as recorded in the appellate court judgment. आप कौन सा बोल रहे थे? आप 1231 and 1236 को बोल रहे थे।
1231, 1236.
नहीं, it is plot number 1066 and 1067. 1066 and 1067. ये शेड्यूल में नहीं है क्या?
इसको तो एक्सक्लूड कर दिया है इन पीपल सोल्ड प्लेंटिफ दूसरा
शेड्यूल में दिखाई है। शेड्यूल में तो ये है ना तो ये जो कहना है कि बल इंक्लूडेड इज नॉट करेक्ट
some other plot
other plots at this stage is that correct?
Yes, ma'am.
Yes.
At this stage, it has been submitted by the learned counsel for the parties that the sale deeds were in connection with plot number 1066 and plot number 1067. In khata number 36, but the plots which were excluded were plot number 1231 and 1236 and also plot number 1250. The learned First appellate court recorded finding after considering the oral evidences as follows, inverted comma. It therefore appears, page number 34 ma'am. It therefore, comma, appears from the evidence referred to above that Sheikh Chakru, comma, the son of Sheikh Fagu, born of his first wife, and Sheikh Binu, Sheikh Muka, Sheikh Sabadli, and Sheikh Sahadali, sons of Sheikh Fagu, born of his second wife, were in separate cultivating possession on specific plots exclusively soon after the death of Sheikh Fagu, deceased, and thereafter the descendants of the aforesaid 5 sons of Sheikh Fagu, deceased, are continuing in cultivating possession of those specific plots. Full stop. It further appears from the evidence aforesaid that there is no paper of partition evidencing the fact of partition between the parties to the suit, and Jamabandi is still continuing joint between the parties in the name of Sheikh Faga in respect of land of Khata number 36, 11 and 110. Full stop. It further appears in view of the facts referred to above that the plaintiff respondent had dealt with the land in their exclusive cultivating possession by executing 2 sale Exhibit D series, full stop, relying on the case law reported at Exhibit D series तक इसको डॉट 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 करके छोड़ेंगे और इन्वर्टेड कॉमा क्लोज करेंगे. Thereafter, the learned first appellate court recorded the submission of the defendants by referring to the judgment passed by Honorable Patna High Court reported in 1993 within bracket 1 bracket close PLTR 172, who had submitted that one of the essential ingredients for grant of decree is proof of unity of title and unity of possession. An inference of previous partition can be drawn only on the basis of various circumstances, comma, such as separate residence, comma, possession on payment of rent, etc. And this features primarily applicable in case of Hindu joint family can be applicable for similar inference of previous partition of a Muslim family as well. It was also submitted before the learned first appellate court by relying upon the judgment passed by Patna High Court reported in 1984 PLTR 603, in which it was held that to submit that where parties have been in possession of land exercising right of ownership over separate blocks of land over a long time, the court might well presume that these lands have already been devolved and the rights of the parties defined with regard to them in such manner as to preclude their being repartitioned. And in order to bring home the aforesaid point, reliance was placed on Exhibit D series, whereby the specific portion of plot number 1066 and 1067 was transferred by sale and one third by transferring only 1/3 of the share, and the left was left in the share of the plaintiffs. On the basis of these 2 sale deeds, it was asserted that these two statements clearly show that there had been partition of the suit property. It was not in dispute that parties were separate in mess residence and cultivation with respect to specific plot. It was also asserted on the part of the defendants that continuation of joint jamabandi can never be in itself a ground to disbelieve the case of partition. And for this, reliance was placed upon the judgment passed by Honorable Patna High Court reported in 1936 within bracket AIR 1936 Patna 68. It was also asserted that even the survey purcha had no relevance, which was not admissible to show evidence of jointness. The learned First Appellate Court recorded a finding in paragraph 17 itself that in view of the evidence on record, it was crystal clear that the plaintiffs and the defendants had their separate mess, separate residence, separate cultivating possession of the land in question, and separate residential house soon after the death of said father. The court further recorded that it appeared that the plaintiffs had also separate dealing of the property in their exclusive possession by executing said deed. The court held that in view of the facts of the case coupled with the principle of law, held as a question of fact that the facts discussed in the judgment conclusively proved that there had been meets and bound partition of the suit property pertaining to Khata number 36, 11 and 110. And was of the view that the learned trial court, that the conclusion of the learned trial court that there has been no previous partition by meets and bound was incorrect. The learned First Appellate Court thereafter considered the plea of allotment of smaller portion of land to say Chakru in paragraph 18, and considering the materials came to a finding that since best land was given to say Chakru in the said partition, therefore it cannot be said that said Chakru was given unequal share of land. And on this ground, the partition cannot be reopened with respect to Khata number 36, 11 and 110. The learned court thereafter considered the properties in connection with khata number 80, 88, 89 and 90. And was of the view that admittedly these properties do not stand in the name of Sheikh Fagu, the common ancestor of the parties, and ultimately held in the judgment by deciding other issues that these properties were self-acquired properties of the concerned persons and could not be subject matter of partition. यही finding है ना? Appellate court. The court held as a question of fact that the plaintiffs or their predecessor in interest Sheikh Chakru had no right, title and interest as well as possession over the land in khata number 88, 89, 90 and 80. The first appellate court ultimately held while deciding point number 3 that the defendants have proved the case of previous partition with respect to khata number 36, 11 and 110 between Sheikh Chakru on one hand and other 4 sons of Sheikh Faga born through his second wife on the other hand. Full stop. The court further held that khata number 80, 88, 89 and 90 were the self-acquired properties of the concerned persons. And the claim for partition with respect to plot number 80, 88, 89 and 90 was not maintainable. And consequently, the first appellate court ultimately dismissed the suit, right? And the claim of partition by the plaintiffs was rejected. The learned counsel for the appellant, by referring to the substantial question of law, has submitted that there is no concept of unity of title he has submitted that the principles of Mohammedan law in the matter of succession is different from that of Hindu law. He has submitted that under the Hindu law there is a concept of unity of title and unity of possession, and the descendant gets a right to property by birth, and there is a concept of co-partner under Hindu law. He submits that so far as Mohammedan law is concerned, the question of devolution of property arises only upon death and not prior to that. He submits that there is no concept of unity of title under Mohammedan law, as the co-sharers upon devolution are tenant in common. He has further submitted that each co-sharer has definite share with respect to the property devolved. And the co-sharer has a right to sell the property to the extent it devolved upon him. The Learned Counsel submits that Exhibit D and D/1 reveals that only to the extent of 1/3 share of the property was sold by the plaintiff and remaining was left for the dependent. And there is a clear finding that the plaintiff had sold only that portion of the property which was in their possession and to the extent of 1/3 share. The Learned Counsel has submitted that merely because the plaintiff had sold property in connection with 1/3 share in plot of his possession in plot number
1066 and 1067.
1066 and 1067, the same cannot lead to a conclusion that the entire property of Khata number 36, 11 and 110 stood partitioned previously. Though admittedly the property continued to remain recorded in the name of common ancestor, and even the rent was being jointly paid. The Learned Counsel has submitted that mere recording of funding, the Learned Counsel has submitted that under the Mohammedan law, each legal year is entitled to a share in each and every property. He has submitted that merely because there was a finding that they were separate in mess and cultivation, the same cannot be used to draw an inference under Mohammedan law that there was previous partition, though such inference can be drawn under Hindu law. The Learned Counsel has, what was the judgment happened? Has relied upon the judgment reported in 2007 close code SCC 167 para 17 to submit that the party who pleads previous partition has to prove the same, and even if there is separate possession, the same will not lead to presumption of partition. ये मुस्लिम लॉ से केस है.
ये हिंदू लॉ, ये एससीसी का सेंटेशन है.
He submits that though he submits that though this judgment arises out of Hindu law, but the principle of law that mere separate possession will not lead to an inference of previous partition would be common both in Hindu law and Muslim law. Correct?
Yes.
The Learned Council then referred to the judgment passed by Honorable Allahabad High Court reported in 2000 AIR 2007, Allahabad 198/12, to submit that possession for convenience does not mean partition. He submits that this principle of law is also common in Hindu law as well as Muslim law.
This is the case of Muslim
Uh,
party.
he submits that this judgment arises out of a decision passed in the case of Mohammedan law. ये क्या चीज है? ये तो आप केस ही नहीं के मद्रास वाला आप ऐसे लिख के दे दिए.
2025 मद्रास केस किया.
25.
2025 मद्रास 2 paragraph 17.
The Learned Council has then referred to the judgment passed by Honorable Madras High Court, reported in 2025 SCC Online Madras 56108,
Yes.
paragraph 17 and 27, to submit what?
But same not living separate as per convenience.
To submit that ये जो अलाहाबाद वाला लिखे है ना, ये भी मोहम्मदन लॉ से है.
ये not parties नहीं, parties Hindu.
To submit that even under the Hindu law, mere living separate by convenience does not mean that there was a previous partition. Okay, sir? Or big budget.
18 place came to the 18.
The council appearing on behalf of the respondents while opposing the prayer, while opposing the prayer of the appellants, has submitted that so far as substantial question of law number 2 is concerned, the same loses its relevance by virtue of its modification, inasmuch as it is not a case that all the co-defendants had admitted that the property in Khata number 36, 11 and 110 was joint family property and could be subject matter of partition. He submits that only some of the defendants had admitted this position, and therefore it was incumbent upon the court to go into the issue as to whether there was any previous partition or not, which the learned First Appellate Court has gone into and come to a definite finding of fact that there was previous partition. He submits that while coming to a finding of fact regarding previous partition, not only the documentary evidences placed on record, but also the oral evidences have been considered. And merely because the property stood recorded in the name of father and the rent was being jointly paid, the same cannot be looked in isolation to discard the plea of previous partition. The Learned Council submits that the principle of Hindu law and Mohammedan law, while scrutinizing the plea of previous partition, falls on identical footing. And since this principle has been applied and there is no illegality in applying this principle, there is no scope for this court to enter into the point as to whether the learned first appellate court has rightly arrived at a conclusion to come to a finding that there was no previous partition. That there was previous partition. We submit that application of principle and coming to a conclusion is different from the very applicability of principle of law. We submit that as per the first substantial question of law, it is only the applicability of the principle which is under challenge, and the applicability of principle of Hindu law in Mohammedan law is under challenge, and there is no scope for reappreciating the materials and coming to a different finding that there was no previous partition with respect to Khata number 36, 11 and 110. The Learned Council has submitted that the Learned First Appellate Court has themselves considered the various judgments to come to a conclusion that such principle is applicable to Mohammedan law and has applied such principle to the Mohammedan law. He has referred to the judgment passed by on the Patna High Court, reported in AIR 1936 Patna 68, which has also been referred to by the Learned First Appellate Court. And submits that in the said case, though it was arising out of Hindu law, but it was held that the parties were separated in status many years before the suit. Although there was no formal partition between the parties, and they remained in possession of their respective share and were exercising their right and ownership over separate blocks of land for a long time. And in such circumstances, it was held that the court might presume that there was already a partition between the parties. And in such a manner as to preclude their being repartitioned. The Learned Council has ये पैराग्राफ कोट करना है, सेकेंड पेज का जो मार्क पोर्शन है इसको कोट करेंगे, ग्रीन से मार्क किया। इसको कोट करेंगे। The Learned Council has then relied upon the judgment passed by Honorable Patna High Court reported in 1984 Patna 603. It also arises out of a judgment passed under Hindu law and has referred to paragraph 7 and 8 of the said judgment, which is quoted as under. He submits that the very act of the plaintiff in transferring property with respect to his share was material evidence based on record indicating previous partition. The Learned Council then referred to the judgment passed by Honorable Patna High Court reported in 1993 1 PLDR 172 determines that the case was arising out of decision passed in Muslim law, under Mohammedan law, and in the same case, a specific finding was recorded regarding previous partition based on separate residence, separate possession, separate payment of rent, separate transaction and cultivation of land separately for a long time by the same branch, and an inference was drawn of previous partition. He submits that in paragraph 22 of the said judgment, it was held that the presence of same factors, in view of the presence of same factors, inference of previous partition of a Muslim family can be drawn. The learned counsel submits that the present case, the answer to the first substantial question of law appears to be squarely covered by the judgment passed by our Patna High Court, reported in 1993 1 PLDR 172. The learned counsel then refers to the judgment passed by Honorable Allahabad High Court, reported in 2007 Supreme within bracket ALL bracket close 1948, equivalent citation AIR 2007 Allahabad 198, and has ये तो आपने रिलाई किया है ना, आपने रिलाई किया, आपने तो नहीं रिलाई किया, इन्होंने रिलाई किया, इन्होंने ये 2007 अलाहाबाद आपने रिलाई किया,
2007 Allahabad में हम लोग
आपने रिलाई किया, I will just come to that.
Yeah, we have done that. 92 Allahabad, yeah, 92 Allahabad to 15.
एक सेकंड 1993 अलाहाबाद. The learned counsel has relied upon the judgment passed by Honorable Allahabad High Court, reported in AIR 1992 Allahabad 215 paragraph 5 to submit that partial partition is not maintainable. However, he does not dispute that the plea of partial partition, the plea in connection with partial partition has been rejected by the learned trial court, and no substantial question of law to that effect has been claimed by this court. Okay, आपका कोई judgment छूटा?
No.
The learned counsel for the appealant in response has submitted that the judgment passed, the judgment reported in bracket 1993 bracket close 1 PLDR 172 is distinguishable on facts, right? And he has referred to paragraph 6 of the same judgment and has submitted that in the same case there was a previous partition suit and ultimately share was allocated in the previous partition suit. and therefore the fresh partition suit was held to be not maintainable.
Was previous partition suit with respect to the common properties. And this partition suit was with respect to the properties which were in the
There
name
was
of
previous
defendant.
partition suit with respect to the common
Common
property,
properties.
and the subsequent partition suit with respect to other properties
Other
was held
properties.
to be not maintainable.
Yes. And landlord's rent was also being paid separately because
He has
it
also
was in their
submitted
name.
that in the same judgment, all the basic points to draw inference of previous partition were available, including the
Record of rights and rent.
record of rights,
And rent being paid in the name of defendant.
recorded भी अलग था सब.
Recorded भी अलग.
Including record of right, and also the fact that the rent was also being paid separately.
Separately.
He has referred to paragraph 60 of the same judgment. 60 में है ना सारा चीज, सारा element.
हाँ, element 16, element plus 53 में.
60.
नहीं, 53.
The plaintiff could not prove his case. उसके बाद, on the other hand, namely separate residence, separate possession, separate payment of rent, separate transaction and cultivation of land.
Paragraph number change हो गया होगा, तो मेरे पास सुप्रीम कोर्ट वाला citation.
अच्छा. Paragraph 60 में मेरे पास है.
ठीक है.
ठीक है. Paragraph 60.
But this fact is there notes. ये अलग record of rights भी अलग था and rent भी अलग payment was. Defendant.
The learned counsel has then referred to the judgment reported in 2007, AIR 2007, Allahabad 198, equivalent is 2007, Supreme within bracket Allahabad 1948, 1948. And has submitted that no evidence had come in the same case to show that precise shares were allocated to each of the brothers with respect to the properties. And it was held that if the parties were in occupation on the basis of convenience and were in possession of certain portions of the property, that by itself does not mean that there was partition by meets and bounds. The learned counsels had submitted that the plaintiffs are entitled to their respective shares in all the properties, and therefore merely because there was transfer in connection with 1/3 share with respect to only 2 plots, the same cannot lead to a conclusion that there was previous partition with respect to the entire property. He submits that in this respect, the applicability of drawing an inference with respect to previous partition would differ in Mohammedan law, and the same principle cannot be applied, the same principle of Hindu law cannot be applied to Mohammedan law. Yeah. अच्छा, with respect to substantial question of law number 2, आपको कुछ बोलना है इसमें? कुछ बोलना है आपको? The learned counsel for the appellant has submitted that he has nothing to say. He also could not dispute that once there was different stand of the co-defendants, the point was required to be decided by the court based on evidences placed on record. and the case could not have been decided on admission by the defendants. Correct? दिखा गिनने तो दिखाते दिखाते उनका हालत खराब हो। सौरभ बहुत ध्यान से लिखाए हैं और हम सबके सामने लिखाए हैं। वीडियो खोलिएगा, चेक करके अपना पूरा करिए और कहीं पर भी अगर प्रॉब्लम हो तो हमसे आके पूछ लेंगे। विद द पैसेज ऑफ टाइम थोड़ा थोड़ा चीज मेमोरी से देना है। अब क्या करें? तो फाइनेंस लिखाना है इसमें।
नहीं कोई दिक्कत नहीं है, आप जब चाहिए हम कभी भी लिया
एक बार इसको टाइप होके आएगा, आज तो नहीं होगा।
नहीं कोई दिक्कत नहीं, आप जब रखा
आज तो नहीं हो पाएगा।
जब रखा जाए
टाइप हुआ करेक्शन होगा तो मंडे ट्यूसडे व्हेनेवर इट इज कन्वीनिएंट।
नेक्स्ट वीक में ही कोई डेट में रखते हैं, लिखाएंगे हम बोर्ड पे। I have to make up my mind before I exactly.
नोट में आल्सो नोट मेरे सबमिशन नंबर 93 1 पीएल जा रहा है, पैरा 19 उसका खरीद
खाली देख लेंगे अभी।
हम हाँ ठीक है।
कौन सा सबमिशन में जहाँ आपने 93 जहाँ इनका 93 1 पीएल का रेफरेंस है ना,
नोट जो जजमेंट अपीलेट कोर्ट पे कंसीडर हुआ
हाँ।
उसी में पैरा 19
उसमें पैरा 19 का किसके रेफरेंस है?
हाँ हम दिखा रहे हैं, हम पढ़ रहे हैं। Learned Counsel has submitted that onus to prove previous partition was upon defendant. Learned Counsel further relied upon para 41 and 42 of Mullah Principles of Hindu Law. It was further submitted that Muslims have a particular and definite share in the joint family properties. They are entitled to transfer any land out of his share, and no inference of previous partition can be drawn on basis of such transaction alone.
Para 19 of the judgment
Of 19
of 1993.
1 PLGR,
1 PLGR 172 para 19.
Yes.
Two, which is quoted as under, इसको quote ही कर दीजिए, ठीक है? The Learned Counsel has submitted by referring to para 19 has submitted that the principles of Hindu law with respect to previous partition and the parameters are not identically applicable to the Mohammedan law. इसमें कोई बहुत जजमेंट नहीं मिला, वो एक खाली उसमें पासिंग रेफरेंस कुछ तो करते हैं। जजमेंट ही मिल जाएगा तो सेकेंड अपील ही इसलिए चलिए इसको जितने जजमेंट से ना समझ जो जजमेंट रेफर किए हैं उसका लिस्ट वो पैराग्राफ सबसे पहले वही देंगे, हम लोग उसको अकॉर्डिंगली उसमें टाइप करेंगे, ठीक है? As the court time is over, pose this case for further dictation on Monday 2:15. Monday at 2:15.